I recently read that privacy is the new currency. I thought this is a great phrase, a great tagline related to modern estate planning. So today, let's talk about privacy in the context of modern estate planning. Let's get into it. All right, modern estate planning in the context specifically as it relates to privacy. Privacy is the new currency. So one of the things that we talk about a lot is privacy. And privacy means a few different things in the context of estate planning. But in general, privacy means keeping assets or keeping your name as it relates to owning assets out of public view. It could be real estate, it could be operating businesses, it could be getting assets out of your name if there's some type of creditor, right? So it may be that it's not something that is as easily publicly visible, but it could be something that is easily visible when it comes to a lawsuit. So the idea with privacy is that we create different types of structures, business entities as well as trust. When I say business entities, I mean limited liability companies, LLCs, and FLPs, family limited partnerships, or a combination of these, as well as trusts. Mostly irrevocable trust. It could be irrevocable trust, but we'll just generically say trust. We use these different structures to get assets out of individuals' names. Again, the idea is that you own as little as possible in your individual name, and we create these structures that allow you to have privacy. Not secrecy, there is definitely a difference, but privacy, to be able to take your name off and to still legally own these assets in a way that you have control, I should say, allow you to control ownership of these assets or control management of these assets in a way that allows you to still have beneficial enjoyment over them, but not have them in your individual name. So the significance of this is that it really helps with a few things. One, it helps with asset protection. The more private your assets are, the more asset protection you're going to have, in the sense of personal creditors are probably not going to come after you as much. You're probably not going to have as much of a target on your back related to people trying to seek you out specifically for purposes of suing you because you have deep pockets. And then also control when it comes to these assets. Maybe a better way is to say you have a control in the sense of having a family governance mechanism related to how the family wealth is used, usually with the future generations or the subsequent generations. All right. So you often hear me talk about which states have the best trust laws available. South Dakota is by far the most recognized state as having the best trust laws. Nevada is a close second. But what really makes South Dakota unique is its privacy trust laws. Two things that pop out: quiet trust, and then also the perpetual court seal that's available or that's required in South Dakota. So I'll talk about quiet trust. Quiet trust simply means that the grantor, the settlor, the person setting up the trust, has the ability to eliminate or make available the details of the trust to the beneficiaries. And that control can be given to the trust protector, to the trustee, to the investment advisor, to the distribution advisor. It can be controlled by other people. It can be a complete elimination, or there can be discretion given to any of these fiduciary roles to be able to minimize or control the amount of information that goes to the beneficiaries. This is significant because other states require that the beneficiaries be notified when they hit 18 years old of what their benefit is. Meaning what their benefit is, the distributions that they are permitted to have or could have, and then also the type of assets that are and investments that are owned by the trust, as well as accounting, trust accountings, right? So there's different information that's available to them. Now we have the ability to eliminate that. Why would you want to eliminate that? Maybe you don't want your kids to have a sense or an overly strong sense of these assets are available to me, so I'm not going to work too hard in life. You don't want them to become trust fund babies. You want them to have a sense of responsibility. You don't want them to lean too heavily on these assets and trust. So you make sure that you eliminate that possibility by eliminating the ability of them to access that information. So that's the first thing, quiet trust. Most states say that you have to notify the beneficiaries. So South Dakota is unique in that regard. The other aspect, and it's so important, is the privacy laws around trust related to what happens if there's some type of court proceeding related to a trust. So in South Dakota, to the extent that there is some type of court proceeding or court hearing, a litigation, whatever it might be related to the trust, the details of the trust are stricken immediately from the court records and therefore never allowed to become part of the public domain. Okay, so that means that people aren't going to figure out who the beneficiaries are, what the distribution provisions say, who works in the various fiduciary roles of the trust. So that's fantastic. Now, why this is important? Because we see this in other states. There's a lot of different celebrities out there: Prince, Kobe Bryant, Rupert Murdoch. You can look these things up, and details related to their estates are out there. I think with Prince, it's because he had no estate planning. Kobe Bryant, I think, forgot to name his daughter. They set up trust planning that didn't include his youngest daughter before he passed away. So they're going through the court process in California related to a judicial modification of the trust. Rupert Murdoch, a billionaire who owns various media companies, including Fox News. He set up a Nevada trust, and I bring that up specifically because it is Nevada trust. Nevada is known for having great trust laws, but when they were going through that process in the last year or so, all the details related to that litigation become part of the public domain. And we saw, even again, he owns Fox News, or is the majority owner of Fox News, but Fox News even reported that. So anyone can access that information going through the court system. I know Nevada, I believe, allows to the judge's discretion to eliminate or strike any of that information from public record. There is no perpetual seal that's required. Delaware does have it leaves it to the judge's discretion as well, but it's only up to 3 years that they can seal any of that information. So it's really not that helpful at the end of the day. So if privacy is a big concern to you, then South Dakota, the laws that you can leverage with South Dakota, with the private trust or the privacy of the automatic perpetual seal, super important. And then also the quiet trust, incredibly powerful and unique to South Dakota. You can still set up different structures to try to eliminate the ability of maybe other parties knowing, such as, if you want to keep what assets or you control, such as an operating business or something like that. That's easier, right, with LLCs, LPs, trusts. But if you want to protect your own family and have a sense of family governance, then you really are going to have to use South Dakota to be able to eliminate some of those possibilities of beneficiaries knowing. So make sure that if you're using privacy, you're using the right, or you're focused on privacy, you're using the best trust laws available for you to be able to accomplish this.